Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Sweet & Maxwell, THOMSON, REUTERS. It's part of the property and conveyancing library for that publishing firm, and the book is called Gale on Easements. It's now in its 20th edition, so it's been with us for a long time, and it's currently edited by Jonathan R. Gaunt, Queen's Counsel, and Sir Paul Morgan, who's a High Court judge. Now, my wife Elizabeth and I talked about this book in detail. I love the law of easements. It's a part of my practice, and it's a great subject to lecture on, certainly for undergraduates, because you've got so much in human interest stories in it, and of course it's really about neighbours' disputes, which makes up quite a large amount of the issues in real property. It's certainly an interesting area. So the title for our review is The Classic Text on Easements for the 21st Century Practitioner. And that's actually what we've got here. Now let's have a look at the book first of all. It's this one here. This is the cover. It's a hardback, green cover. There we go. There's the spine. There's nothing on the back. The spine shows you it's the property conveyancing library and the 20th edition, and of course Sweet & Maxwell at the bottom. Now at the back of the book you've got the index. The book runs to just under 800 pages. The index is by paragraph numbering, so you should be able to find things quite easily. It's a detailed index, and there's a legal taxonomy at the back, which is very much part of the house style for Sweet & Maxwell, explaining how the index works. Then you've got a series of drafts. There's in fact a draft law of property bill in Appendix C, because this is an area that does need some revision. There is the front page there, and you can see after that the basic blurb, and then you've got a list of all of the editions of Gale starting in 1839. Then there's an important preface which is well worth reading. There is a use of footnotes throughout the book, and then you've got a preface to the first edition, which is fascinating, from Temple in July 1839. Then there's an interesting point about Charles James Gale, 1805 to 1876. I do think the history of these books is actually very interesting. And then you can see the information. That's been written by Edward Peters of Falcon Chambers. Then you've got a table of contents. The history of the book and the people who've written it, especially when they're Victorians, it is fascinating to actually find out who they were and what they actually, what the books look like as well. If you can go into the law libraries, you can see some of the books, the originals, and they're very interesting. Of course, I would point out they're actually quite small books. These are the content sections here. They are quite small books. A lot of table of cases, of course. Large number of cases. Then a table of statutes. Then statutory instruments, of course. Then you've got a table of practice directions, which I have found very helpful in looking for things. Then CPR, civil procedure rules as well. And then part 1, characteristics of an easement. There we go. And then you've got for each one, you've got a sub-index, if you like, for the chapter, which tells you what's in it. And then the way that the chapter is structured is you have the paragraph numbering at the side, then you have the footnoting. And that's the way it's run all the way through. For instance, we're right in the middle of the book, the Prescription Act 1832. As I say, all of this will be very familiar to many people, because easements is a fascinating area of the law of real property. What is useful too is you have a little divider ribbon, which makes it much easier to find things. I much prefer that to the e-books, which I cannot get on with. And one of the reasons is because you cannot cross-refer the way you would normally do with either a law report or any form of main law textbook or practitioner work. So what do we say about the book? Well, easements. The very word sounds soothing, unless you're a lawyer, in which case you would doubtless agree with the current authors of the new 20th edition of Gale on Easements, who refer, as they did in the previous edition of 2012, to the state of the law on easements and the, quote, the lack of clarity in this area of the law, and they've given a proposed bill, which is at the back of the book, to perhaps bring some more clarity to the subject matter. Another quote: "A disproportionate number of cases go to appeal," they say, referring further to the difficulties inherent in the duty of the judiciary to decide what are often complex issues of fact and law. Well, absolutely, I've been involved in some of these cases, and they are complex, and you're dealing with angry neighbours quite often, and people who just cannot agree with each other because of the vice of pride, never wrong, and all the other problems that go with it. And it's my land, why shouldn't I do what I like with it? Of course, other people who take other people's land and do all sorts of other little things. So you can see all of the problems which come into the mix and make it a fascinating area. Now, this book is published, of course, as I said, by Sweet and Maxwell, and Gale on Easements remains as much the definitive work on easements now as when it was co-authored originally by Charles James Gale and Thomas Whatley, and published in 1839 by S. Sweet, price 16 shillings. And as I said, they practiced from the Temple. And it's perhaps ironic, but not too startling, that the preface to that first edition comments on the then lack of a treatise on these important rights known as the law of England by the name of Easements, which has, it is believed, been sensibly felt by the profession. So you've got the usual rather long-winded Victorian approach, lack of perhaps, well, a bit pedantic, but you get the general drift, I'm sure. And you can see even from 1839 to date, and I'm recording this in 2017, you can see that there is certainly this need for clarity, and I think also we do need a new Act of Parliament in due course. And it's equally unsurprising then that the profession that's referred to has depended on the erudition and authority of Gale on easements for the past 180 years. This is a classic text that has remained forever young via frequent updates, and of course that's one of the great things about the Sweet and Maxwell service. You get supplements, so they keep you, with notice up or whatever it is, they keep you very much up to date. Now, the authors of the current work, Jonathan Gaunt, Queen's Counsel, and the Honourable Mr Justice Morgan, have presided over the previous 4 editions as well as this current one since 1997, so we got 20 years worth from them. But what is an easement precisely? An easement, say the authors, is a right over the land of another. A simple definition, which in reality is not quite so simple as the text explains in detail. Of course, it is complex. If you're fond of word derivations, the footnote tells you that easement is derived from the Old French aisement, meaning convenience or accommodation, and that the modern French word is servitude, which is also used in Scots law. Now, of course, accommodation means you are accommodating someone else's interests over your own property, as what is lovely words, an incorporeal hereditament. Now, you can see we've got lots and lots of funny words, but in essence it means that it's the right someone has over your property. In essence, that's it. And that causes all the problems, all the neighbour disputes and everything else. The subject, of course, is a venerable one, and also it's an interesting one for all lawyers to be involved in, and one which is becoming more rather than less relevant in the 21st century, particularly in a democracy in which the majority of individuals continue to aspire to property ownership. Now, the book is organised into 5 parts, and it examines virtually every conceivable aspect of easement, starting with the manifold characteristics of an easement and proceeding on, for example, to the creation and acquisition of easements, to specific kinds of easement, including rights in respect of water, right to light, rights of way, rights to neighbouring land, party walls, and so forth. And part 5 discusses disturbances, including remedies and costs. The 3 appendices include the relevant statutes and regulations, and there are extensive tables of cases, statutes, statutory instruments, practice directions, and civil procedure rules. And finally, let me say, yes, there are other texts on easements available, but Gale is considered the final and ultimate authority, as it contains all the legal arguments and the referencing I think you might need, and it's used by judges, of course, as well as practitioners, and it's the authority, effectively. It's also been cited in Commonwealth jurisdictions, which I think is laudable. With its wealth of new material, this latest edition of Gale's should be considered an essential purchase for your practitioner library. And the law is as stated on the 31st of August 2016. Let's have a look at it again. There's the book. Do have a look at our reviews on the web and in the journal, the journals. Opening it in the middle, this is Natural Rights in Natural Water Courses. Surface water, no defined channel. So you've got a huge amount of learning going into this book. You can see the structure again, paragraph numbering and footnotes. This is where the law is, putting it bluntly. And without these books, the Property and Conveyancing Library, the Common Law Library, without these books, our lives would be a great deal more difficult as lawyers. But also, I think from the general public's point of view, it's useful to know where you can find specific areas of law which may be directly pertinent to your own problems and your own issues. So I'd like to thank everybody involved in continuing to publish this excellent work. And also, because it's so historic now, bearing in mind how old it is, it's always nice to see the growth and the development of the common law over such a long period of time. It'd been nearly 2 centuries before we blink our eyes. Thank you anyway to everybody concerned for a most enjoyable read, apart from anything else, because you gather I think the subject matter is fascinating. Thank you to all. Bye-bye.